My lord, my lord, in respect of item number 22, my lord, orders, my lord, first item. On my lord 14.5, your lordship has, my lord, granted interim bail, and my lord directed the SP border Borpeta to release him. But my lord, when they went that the all records have been sent to SP border Bozali, my lord. Therefore, my lord, I filed this IA.
You will take it up.
May I please, your lordship? Your lordship, on behalf of this Chaudhary, I beg to mention item number 17, my lord. It will be adjourned for the day, my lord.
Okay, it goes for 2 weeks, but 17. That is at present. Pay counsel for the petition. Stop it. Yes.
Bless you.
May I please, your lordship? I beg to mention for listing one IA lordship. In this
This thing, give it to the court master.
lordship, tomorrow lordship.
Not
In-
tomorrow.
in
Will you
the-
come day after tomorrow? Tomorrow we have some matters fixed.
Lordship, Deputy Officer.
May I please, your lordship? But with the consent of the other side, I'd like to mention item number 70 for lordship.
What is the IA for?
I
What is the IA for? What is the IA for?
Lordship, in that case, lordship, this honorable court directed the petitioner will be appear before the SP border within 15 days, lordship. But the petitioner, due to communication gap, lordship, he did not appear, lordship. Deeply.
Your Honor, lordship, item number 70 for lordship.
Item?
70 for lordship, for orders. Supplementary list, lordship. Your lordship, kindly adjourn this matter for today, lordship, because my senior is out of town today, lordship.
So I have to say something, lordship.
Why it has come for orders?
Lordship, the thing is that the IA has been filed. The IA has been filed for the bail of the petitioner Bipul De, lordship. Then we have approached Honorable Supreme Court, and Honorable Supreme Court disposed the bail application, stating that for 6 months, within 6 months, Honorable High Court have to, if possible, dispose of within 6 months. Then till then he will be in bail. But this has not been disposed of the main criminal appeal. So this order has passed 22nd of December. So till today, his bail is granted, lordship. So otherwise,
Then we can't adjourn it. We'll have to take it up.
Your lordship,
If the Supreme Court says dispose of within 6 months, it was never brought to our notice.
can you lordship, tomorrow, lordship? Because
no,
today-
lordship, no.
can you, lordship?
No tomorrow business. When there's a direction of Supreme Court, no tomorrow business.
Supreme
Do you undertake to file an affidavit before the Supreme Court saying that the matters in the High Court was adjourned at your prayer? Can you give us undertaking? Why it's so difficult? Why it is so difficult to file an affidavit in the Supreme Court? Now you have all online.
lordship, if
You can file it online.
lordship, can you perish the order, lordship, at players, right, lordship, in that petition?
Not required. We'll take it up after, but we'll take it up. No adjournment. Next.
Item 4, my lord. The reference was with regard to the husband and the wife. Now, I have filed 2 cases and both were coming together. But today only the wife's case is there. I'll require the documents. I will be relying on the husband's documents also. Yes. That WPC is, your lordship, 1954 of 25.
Okay. Give it Tuesday, Wednesday, 4th. List on so and so along with WPC.
1954 of 25. Publish.
May I please, your lordship, I would like to mention for listing up a motion matter tomorrow. The person is in detention, lordship,
Not
legally.
tomorrow, day after tomorrow. Tomorrow
Yeah.
we have some matters fixed.
Deputy Officer.
Item 1 for motion.
May I please, your lordship? This is a contested matter, your lordship. I have adduced 2 evidences. Myself and
LCR, are you saying?
the LCR has not been come yet. And the imprint order on page number 37. Disabled also. On the other hand, I have sufficient linkage documents, Your Lordship. In the voter list of 2013, 15,
Where is
2019.
the opinion?
Yes, my lord. Opinion is on page number 37.
Huh? Okay, so I don't keep it.
In the voter list of 1966, 70, 71, my parents' name and my grandparents' name have been here, Your Lordship.
It's a 22 opinion. We'll have to wait for bail for some time.
There is some grounds also, Your Lordship. We have categorically stated in the paragraph.
Whatever,
30.
but 3 years now.
But it was filed on 2024, Your Lordship. And
We never moved it. It was always adjourned on your
so
prayer.
one time we have adjourned.
And one time you were not there.
Maybe given, Your Lordship.
And on one date you were not there.
Yes.
But Mr. S. Islam, then I counsel for the petitioner. The respondents are there. Opinion dated 15/2/2022, passed by so and so and so and so. Is 37. Declaring the petitioner to be a foreigner post 25/3/1970 stream. Notice extra copies within 2 days, call for the records. Give a fixed date after 4 weeks. After 4 weeks, give it fixed date. Notice returnable on so and so. Therefore, bail shall be considered on receipt of tribunal's records. List after 4 weeks. List on so and so.
Mass obligation.
Item 2,
May I please, Your Lordship? Lordship, opinion is at page number 55, my lord.
Page number.
Notice of 2021, 55, my lord. Annexure 11, my lord. Opinion is of 2021,
21.
my lord. LCR has been received, my lord. And I have explained the delay, my
What is the best document you have to connect you to your projected parents?
lord. My great grandfather and grandfather's name was appeared in voter list of
No,
1965.
voter list, you forget the voter list for the time being.
Right.
Any other document to connect you?
Right.
You can-
Uh,
Your projected parents.
my- I have read up to class 10, my lord. So school certificate was annexed as exhibit 1, my lord. 115. And the principal of that particular school was adduced as OPW 4, my lord, page 51, my lord. And Gabura certificate was also
51.
51, my lord, annexed 10. That I have translated it, my lord. Annexed 10, my lord. Burla,
Where is this document?
my lord. The vernacular is in 50. It is in the LCR, my lord. I could not collect that at the time of filing, my lord. I'm extremely sorry, my lord. It has been exhibited as Exhibit 1, my lord. Was 1975 body.
Mr. Pine, we are granting bail to the petitioner. He has some connectivity with the documents. But Miss SSZR, learned counsel for the SSZR, counsel for the petitioner. The respondents are there. Pursuant to order dated 22/4/2024, the records of the tribunal is received. So accordingly, the learned counsel for the petitioner is laid for bail, which is opposed by the learned standing counsel for the FT matters on the ground that as per the impugned opinion, the petitioner has not been able to connect herself to the or projected parents and grandparents. Next paragraph. As the records have been received, the court is inclined to issue rule returnable forthwith without requiring any steps to be taken. As all the respondents are represented, establish the matter for hearing in the month of August 2025 on a date to be fixed by the registry. Next paragraph. Consider the prayer made by the learned counsel for the petitioner for bail, as well as the objection made by the learned standing counsel for the key matters. As the petitioner claims that is the name of her grandfather appeared in the Jamabandi of 1930-31. The court is of the considered opinion that for examination of records is required. Accordingly, in view of the projection made in this writ petition, the court is inclined to grant bail to the petitioner, namely so and so. 10 days time to take bail. In that bail order, you write the bail in connection with opinion dated at page 55.
55 minutes.
Opinion dated 26/11/2021, passed by so and so in so and so, corresponding to so and so. Ten days time to take bail, this 5,000 to the satisfaction of
Nagaon, my lord.
SP border Nagaon. Hearing a date, a list on the month of August 2025 for hearing on a date to be fixed by the office.
Highly obliged, my lord.
Item 3, motion.
Lord, on the last occasion, your lordship heard this matter, and your lordship was pleased to stay the interim order. And while passing the order, your lordship noticed that there is some correction in respect of response number 6. Accordingly, amended custodial is
Has been filed.
submitted, your lordship.
Which page is the opinion?
My lord, page 41 onwards, your lordship.
So Sharma, we are granting bail. He's appeared with, is filed within time. Mr. A. Rahman, the counsel of the petitioner. All the respondents are there. So could you on behalf of A. Ali?
Oh, good.
Opening is at page 41. Opening date 28/3/2024, passed by so and so in FT case number so and so, IMDT case number so and so. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the records. Therefore, bail is opposed by the understanding counsel for the FT matters. A review of the projection made in this repetition. 10 days time to take bail. Or rupees 5,000 to the satisfaction of
SP Golparayalo.
SP Border Gwalpara.
Item 5,
Yes, what has happened?
My lords, your lordship, he applied for ETC, emergency travel certificate, that has been issued. But now my learned senior has told that we have to apply for exit permit. Now exit permit.
Can you just show that document?
Immediately on 20th evening, my lord, I asked my friend about the update. Then he informed that my lord, ETC has been issued. It was around 8 o'clock. Immediately I contacted the FRRO, the Foreigners Registration, Regional Registration Officer, Kolkata. She was in touch with me. Then she told me, she asked me to upload those documents, course order, and the ETC in their e-module. Well, accordingly, I shared the information to my friend.
Good.
Well, he failed to do it. Then again, I got back to her. I told her that these are the difficulties the council is facing. So please advise. There was no response from their side. That was on 28th evening, madam. It was around 10 o'clock. On 29th, madam, again I wrote a letter. No email, but I sent it. I had sent the letter on 28th. Well, that was responded. That has been responded by her. But 29th letter, madam, she has not responded. So madam, these are the letters, communications I had made. You know, can you produce this?
That
These
is,
are.
that is good. Very good effort you have done.
Yes, madam, I have done my best. Madam.
No, we appreciate that.
Mhm.
Yes.
Yes. But that 28th letter, madam, I have only one copy, madam.
It's okay. We'll just look into it and return.
29th I have, madam.
Now, what is the hitch in your traveling out of India?
No, I have been informed that we are additionally need a travel permit, exit permit that we have to apply for FRRO. I was informed on 28th and I tried to apply, but the problem, the issue is that the website, it has to be applied. The foreigner himself has to apply it. And the other problem is, the other issue is that I am also concerned is this was issued on 22nd May. On the superintendent, he received on 28th May. Now this is only valid for 1 month, from 22nd May to 22nd June. And
He is detained in
Matia, transit camp Matia.
transit camp Matia. So, Mr. Payeng, using your office, you'll have to allow him to make entry in the FRRO.
Department already on letter issued to squad and police border on my lord 14/5, but till then without police.
Actually, I was not party in this case, so that's why I could not get the instruction. Just now, my other friend has asked me to get the instruction what happened. So I was therefore for the mechanism of call. I can get instruction by tomorrow itself, no issue about it. If transit permit is there, definitely it can be traveled. There is no issue.
But if you have to apply, then your authorities will have to give him access to computers and application.
That facilities I can provide there in the party. I don't think there is any problem. But only I get instruction by tomorrow. Actually, I
It's
was
okay.
not
We are
by-
fixing it day after tomorrow then.
Yes. It would be maybe short, but because I'm not a party in this.
I'm filling the form.
Okay. Just give a copy to
Yes,
Mr.
I'm
Payeng.
Immediately.
Mr. D.K. Agarwal and counsel for the petitioner submits that uh, emergency certificate.
Emergency travel certificate.
No, it says only certificate, emergency certificate. Emergency certificate has been issued in the name of the petitioner. Give the name, so and so. Huh? Which was issued by the Nigeria High Commission of New Delhi on 22/5/2025.
22nd.
Full stop. They submitted that the copy was, physical copy was received on 28/5/2025. Stop. However, he is instructed that the petitioner would have to himself apply for a transit permit before the FRRO.
Exit.
Exit permit. Okay, exit permit through the FRR, concerned FRRO, which can only be applied online by the petitioner. Next, as the petitioner is currently lodged in the transit camp, Matia Gwalpara. We have requested Mr. J. Payeng, Leonard Standing Counsel for the FT matters to transmit a downloaded copy of this order to the Superintendent, Transit Camp Matia Gwalpara, as well as to the concerned officials of the authorities of the Home and Political within bracket B, bracket close department, so as to facilitate provide facilities to the petitioner for making an application for issuance of a exit permit through the online mode before the FRRO. Before the FRRO. Which place?
Kolkata.
Kolkata. Next para. We take note of the submissions made by the learned counsel for the petitioner that the emergency certificate issued on 22/5/2025 would be valid only for a month. And therefore, there is every likelihood that the same would expire on 21/6/2025. Next paragraph. By an order dated 16/5/2025, the court has already implemented the Ministry of External Affairs, New Delhi, as respondent number 3. So necessary correction of the cost title has been made by the registry. Next paragraph. We have noted the various communications made by Mr. M.R. Adhikari, Commandant CGC, to the concerned authorities, including FRRO Kolkata, as well as to the Ministry of External Affairs, and to the FRRO, Kolkata. We put on record our appreciation to the effort taken by the learned CGC in the matter. Accordingly, let a copy of this order be also transmitted by him to the respondent number 1 and respondent number 3, so as to enable them to communicate with the Foreigners Regional Registration Office, Kolkata, so as to facilitate issuance of the exit permit for the petitioner, namely, so and so. Next para. List on Wicked Friday, Thursday, 4/6/2025. So as to enable the learned standing counsel for the FT matters to provide information as to whether appropriate facilities have been made available to the petitioner for making an online application for issuance of before the FRRO Kolkata for issuance of exit permit. Next para, list on so and so. We are returning our documents. Yes, 6 and 7.
Wait, please, Your Lordship. Your Lordship, earlier a proceeding was drawn against the petitioner, Your Lordship. That
Okay.
matter is pending.
Mr. Pai, please, you've gone through the records.
Yes.
Just go through it because there are two opinions. Earlier here, earlier there's already an opinion which is challenged by filing WPC 79 of 2021. He has received a second notice. Both the records are here. Just go through it so that we save our time. Go through it and address us. We'll take it up after some time. The privacy, we find that he has been, there is already an opinion against him. So second proceeding. But check it. Check it. I don't want to spend time on going through the LCR. Wait, hold on. ये प्रोग्राम सुषमा फिर जाएगी ये असेसमेंट का एक होना से ना ये नहीं होना से
नहीं जानी सुमन जी
Item 8.
The opinion is at page 34 and extra 5.
So BJ Mukherjee and counsel for the petitioner, the respondents are there. Opinion is at page 34, 29/1/2025, passed by so and so in FT case number so and so, PE number so and so. Notice extra copies within 2 days, call for the records. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this writ petition. 10 days time to take bail, sum rupees 5,000 to the satisfaction of
Chirang, Your Lordship.
SP Border Chirang.
Chirang.
Okay.
Much obliged.
Item 9. Item 9.
My lord, in this case, my lord, I would not like to argue, my lord. It's my fault, my lord. On 11 dates, my lord, I didn't appear. It's ex parte order, my lord. At Kanisi page 18, my lord. Page 18, man. Consecutively quite taken.
It's an ex parte opinion.
Ex parte opinion, my lord.
We'll call for the records.
Motion pay for that.
May I pray, my lord? My lord, since it's ex parte order, my lord, heavy cost may be imposed on me, my lord. And it may be remanded back to my lord, Honors Tribunal, my lord. It's my fault, my lord. I didn't appear, my lord. I have submitted my lord written statement, my lord. Opinion is page 28, my lord.
But from your, from which document you're trying to show that your parent or grandparents were Indian?
At page 32, my lord. Page 32.
Yes. You are referring to which entry?
My lord, 1965, Putal race. Page 32, Khala Ali, my lord.
Okay.
And I'm also, my lord, I am, my lord, original inhabitant of Assam, my lord. There's a 5, my lord, class, the government of Assam has declared, my lord, as an indigenous inhabitant of Assam, my lord. I'm a Khilonjia, my lord. I'm an Assamese Muslim, my lord. To that effect, my lord, I have annexed a certificate, my lord. Page 31A, my lord. My mother tongue is Assamese. I'm an Assamese Muslim, my lord. I cannot be, my lord, Bangladeshi national, my lord. That page 31, my lord. Kindly see page 31, my lord.
Yes.
Majid Ali, son of Hafiz Ali, mother's name Mina Begum of Baligaon, Nagaon district. Assam belongs to Moria community, my lord. Moria community, the government of Assam recently, my lord, the last year government of Assam has declared as an indigenous, my lord, Muslim. Indigenous community of Assam, my lord. My mother tongue is Assamese, my lord. I'm an Assamese Muslim, my lord.
But how do you connect yourself to your projected parents or
At-
grandparents? What is it?
My lord, kindly page 19, page 33, and 34, my lord. Page 33, my lord. 34. Page 30, translated page is at page 34, my lord. Abdul Khalek, then Khala Ali, my lord. Abdul Khalek, my lord, my grandparent, then grandfather, my lord. Khala Ali, great grandfather, then Abdul Khalek, my grandfather, my lord. Then Hafiz Ali, my father, my lord.
But Mr. Rahman, your documents are insufficient.
My lord, kindly see page 37, my lord. Page 37, I have mentioned my father's name, page 37, my lord. Hafiz Ali, my father's name, my lord, Hafiz Ali. Then my grandfather, Abul Khalik, my lord. Page 37. Link I have established, my lord.
Yes, Mr. Payne.
This is the expert opinion, my lord. Lordship may kindly reduce the orders. Now from this 21 onwards. Orders of the tribunal. my lord. Page 21, notice was served. Then from page 22, my lord, you are supposed to file evidence as per order of 22/12/2015, my lord. page 22, this is the first order. Accordingly fixed the matter for evidence on 4/2016. The matter was fixed for evidence on 4/2016 and that date to till 2018, my lord. Numbers of dates, my lord. Your lordship will find. Up to page 27, my. He filed petition, his advocate files petition for filing evidence and evidence matter for long 3 years, my. 3 years he could not file evidence. And ultimately he disappeared. So this is a clear case matter where he is evading entire process. For 3 years he could not file evidence. Not a single diploma, not a 1 year. It's 3 years.
No, we are not disputing that, my lord. I have admitted at the first instance that, my lord, I didn't appear on 11 dates, my lord. That's why it was, the ex parte order was passed, my lord. The first instance, my lord, I admitted.
Yeah.
Page 13 is a written statement. File on
My lord, 16/12/2014, my lord.
14.
16/12/14.
Yes.
16/12/14, we don't have an order sheet.
That is on 18, my lord, 2018.
Heard. Mr. SSS Rahmat and counsel for the petitioner. Mr. SSS Rahmat and counsel for the petitioner. All the respondents are there. Oh. Filing this writ petition to Article 226 of the Constitution of India, the petitioner is assailed. Ex parte opinion dated 30/10/2018, page 28, passed by so and so and so and so. So the court proposes to examine the. Just say it appears from the documents annexed to the writ petition that the written statement was of the petitioner was filed on 16/12/2014. However, this the order pertaining to filing the written statement is not on record. So therefore, the court proposes to call for the records to examine the same. Next, the registry shall issue a requisition to the Foreigners Tribunal 6th November for the records of FT case number, page 28. At the following email address. Next paragraph. List on given date after vacation for the records. (16/7).
Well, till then, my lord, I may be
No, you're not protecting.
obliged. Obliged, my lord.
Item 6 with 7.
Everything is okay, we stay the proceedings. But so I, Hussein, and counsel for the petitioner. Respondents are there. Mr. Pine for FT matters and Mr. Sharma for NRC. In brief, the case of the petitioner is that in connection with a proceeding under the Foreigners Act, an opinion dated 16/3/2020 has been passed by the learned member, Foreigners Tribunal 7th Sonitpur, Balipara. Para 2 and 3 of order dated 2/5/2025. 2, 3 and 4. Next, pursuant to the order dated 2/5/2025, the records of the tribunal has been received. And moreover, the records of WBC 79 of 2021, which was called for, is also placed before the court. Next paragraph. As the identity of the petitioner in both the proceedings is not disputed, the court is of the constituted opinion that till the disposal of WPC 79 of 2021, the proceedings, the subsequent, the projected second proceeding against the petitioner being FT case number DC 1495 of 2016, pending before the Court of Learned Member, Foreigners Tribunal 7th, Sonitpur, Balipara, shall remain stayed. Next, the petitioner shall communicate, shall produce a certified copy of this order before the said learned tribunal, bring this order to the notice of the said learned tribunal. Next paragraph. Let the records of this writ petition be tagged along with WPC 79 of 2021 for analogous hearing.
Item number 7 may be cartoon very true.
That's why we are tagging this record there.
Yes.
These items, then pass another order in item 7. 7 is ready for hearing.
Ready for hearing.
By an order dated, as you say, all sides are represented, by an order dated 16/9/2021, this court had directed that the matter be listed for hearing full stop. Accordingly, issue rule returnable forthwith without requiring any fresh steps to be taken. Next, as the records are available, let the matter be listed for hearing on in the first week of August 2025.
Look.
Item 10.
May please, Your Lordship. My lord, here, the into an opinion, Your Lordship will find at page 55. It is August opinion dated, my lord, 21/8/2024.
Item, page number?
My lord.
Page
55.
number? Page number?
55.
55, okay. 21/8. Okay, we grant bail to the petitioner.
My lord.
And Mr. A.R. Sigdar, land counsel of the petitioner, the respondents are there. Page 55, opinion dated 21/8/2024. Notice extra copy is into this, call for the records. Therefore, bail is opposed. String the prosecution made in this reason. Bail of rupees 5,000 for the 10 days time. For the satisfaction of SP border Bongaigaon.
Item 11.
11, my lord, opinion is of 15/5/2018. My lord, lordship may
Will consider
only,
fair-
my lord, not to deport, my lord.
not to deport under the present circumstances is also becoming very difficult.
But even, my lord, some situation, my lord, they may try again.
Okay, in this case, he's 64 years now.
Yes, my lord.
Mr. Pai, page 19.
Yes, madam.
64 years.
Issue, my lord, the delay and legit. Because had there been no such situation, my lord, they would not have come.
They would not have come.
Yes.
Yeah,
that
you're
is the-
right. You're right.
Otherwise, they will have been, my lord, hiding.
Situation has helped the advocates, my lord, to get more litigation, my lord.
We are not commenting on that. You already have a good name.
Yes.
We don't want to bring bad name along with it. Mr. A.R. Siddharth and counsel with the petitioner. Opinion at page?
My lord, at page 54.
15/5/2018, page 54. The learned standing counsel for the FT matters has raised a issue of delay and latches in filing of the writ petition after about 7 years from the date of the opinion. But accordingly, it should be keeping the issue of maintainability on ground of delay and latches open. I should notice returnable on so and so. Give a fixed date on so and so. Extra copies within 2 days. That the relevant records be requisitioned. Next para, the learned counsel for the petitioner is paid for bail. So the same shall be considered on receipt of records. Stop. According to the understanding, learned counsel for the petitioner has paid that till the next returnable date, comma, if the petitioner is apprehended, he may not be deported. So the said prayer is also opposed by the learned standing counsel for the FT matters on the ground that despite a lot of effort by the border police and the district administration, comma, the petitioner could not be apprehended till date. Be that as it may, as the petitioner projects his age to be 64 years, it is provided that in the event the petitioner is apprehended, shall not be deported till the next date of list, till the next returnable date. Next list on so and so.
My, deeply obliged.
Hi. 14/7. Mr. Siddharth. Mr. Siddharth, the date we gave was just before vacation. We are making it after vacation.
My lord,
will not be able to take up
My
the
lord.
hearing on those days.
my lord. Deep lovely.
14-7, yeah, fixing.
Item 12.
May it please your lordship. Lordship, the matter may be fixed for time being. My learned senior is busy in other court, your lordship.
Item 72,
Supplementary item 72.
May it please your lordship, my lord.
Mr. Pai,
My lord.
although there is an inordinate delay, but in view of the earlier opinion at page
Yes, yes. I have seen.
40,
This.
we grant an interim protection to the petitioner. Why was the matter adjourned on that day? What was the query of the court? Why was the matter adjourned on 30?
I prayed for withdrawal, my lord, because two read petition, I thought that two read petition will have to file. But later on, I have seen that earlier
Oh,
ex parte
okay.
order was vacated.
I now remember
My
what
lord.
has happened.
My lord, I have seen that the earlier order since vacated, so my lord, they, this read petition, my lord.
Which order you are challenging now?
My lord, page, my lord, 58, my lord.
This was
58.
an ex parte order. Third line, my lord, process server could not find out the house of the proceedee on the given address and have hung the said notice in the notice board on Shilpuri Gao Pansayat in presence of witness. My lord. So I was not aware. My lord.
The first opinion is at page
38, my lord.
38.
My lord.
Where is the second opinion?
Second opinion, 58, my lord. My lord, yes, 58, my lord, yes.
Second opinion, page 58.
58, my lord.
Yes, then
Then, my lord, after passing the first opinion, by declaring not to be a foreigner, not a D voter, my lord. So, when the second reference was initiated against me, my lord, and that was ex parte decided, my lord, at page number 40, my lord, 40. It was decided ex parte, and thereafter, page number 42, this is my application under order 9 rule 13 for vacating the ex parte order.
Just now.
My lord.
Mr. A.I. Ali, learned counsel for the petitioner.
A. Ali.
A. Ali, learned counsel for the petitioner. The respondents agree by filing this writ petition under Article 226 of the Constitution of India. The petitioner has assailed the opinion dated 12/6/2023, page 58. Passed by so and so, also declaring her to be an illegal migrant of post 25/3/1971 stream. Next, the petitioner, the learned counsel for the petitioner submits that against the petitioner, there was previously also a proceeding drawn up before the learned member, Foreigners Tribunal, third, Dorong Mogoldari, being FT case number, page 38. FT case number, so and so, inquiry number so and so. Wherein by an opinion dated 24/1/2014, she was declared to be an Indian citizen and not a foreigner or devoter. Considering the same, issue notice is returnable in 4 weeks, extra copies within 2 days. Make it 6 weeks. 6 weeks. Extra copies within 2 days. With the records of page 38 and page 58, we call for from the consent tribunal. Next, the prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the opinion dated 24/1/2014 against the in respect of the petitioner in FT case number 3558/12, referred above, what is inclined to grant bail. 10 days time to take bail, 5,000 to the satisfaction of SP border.
Dorang Mongol.
Dorang Mongol. Okay.
Supply item 73.
Deeply obliged.
May it pleases your lordship.
Yes.
My lord petitioner, his sister was being arrested on 25/5/2025 in spite of the order of the Honorable Apex Court, wherein the impugned order of this Honorable Court was stayed. And thereafter, now again, day before yesterday, she was again brought back. And the order of the Apex Court interim order, lordship, is at page 44. And she was left out in an inhuman condition, lordship.
44.
Yes, lordship. Page 44 is the order, lordship. And page 45 is the relevant portion. Further action pursuant to the order of the High Court shall remain stayed.
But Ms. Ghosh, then this application should have been filed before the Supreme Court by way of an interlocutory application. When the matter is in session before the Supreme Court of India.
Yes, lordship.
How can we pass any further orders when our orders have already been stayed?
Yes, lordship. Because it's a fresh.
Pass any to pass any orders when the matter is in session before the Supreme Court of India.
Yes, Lordship. But and this order also is being informed to the DGP Lordship by one of the local council there on that also I have annexed.
We understand, but you see the matter is pending before the Supreme Court.
Yes, Lordship.
By entertaining a writ petition,
She is brought back.
you would only be passing an interim order when we can't do anything else.
And one prayer also is there. It's for general lordship, which not to push back. A prayer A is a common prayer, lordship, not only with regard to this specific writ petition which is pending before the apex court, but also with regard, it's a general prayer. So procedure need to be followed.
You see, we are not dealing with a PIL where we can take cognizance of whatever is happening. We must concentrate our effort only for the purpose of this petitioner.
Apex court में pending है, you raise it there.
Because you see, if you are under protection,
So I got the point.
you Ms. Ghosh, we're trying to understand. It's not that we have formed an opinion. We're just thinking aloud. You see, if there is a protection, what we read from the order of Supreme Court, which page was that?
Page 44, lordship.
44.
Yes, lordship.
44 says that further action pursuant to the order of the High Court shall remain stayed.
Yes, lordship.
So if that be so, then it amounts to contempt of the order of the Supreme Court of India.
Yes.
By entertaining a writ petition, are we not precluding you from exercising that liberty which you have? Because you can't be agitating in two forums. Please think over, we'll take it up at 2.
Yes, lordship.
Think over.
Yes, lordship.
Yes, what do you say in the meantime?
My lord, first of all, my lord, if the person is there now, my lord, I think the matter is become infructuous. Because admittedly now she has said, my lord, the person is the lady whom she is alleging to be detained is now in their custody, my lord, in their. So where is
She's brought back.
Yes, lordship. She was left in the border at 12 o'clock. So here there is also a prayer is there because of this atrocities which she has faced, because her slippers were removed when she was arrested. She was wearing slippers, and from the photographs which we have annexed, her slippers was removed. So in that such an inhuman condition, and if we see the photographs at page 43, they were sitting in the no man's land in such an for that also she that inhuman torture which she had faced, lordship, for that also she is liable for compensation, lordship. And for contempt proceeding, I will approach Honorable Apex Court. But for this fresh cause of action, lordship, which is being inflicted upon.
Then look at page 32, 33.
Yes, lordship.
You think over, we'll take it up at 2.
Yes, lordship.
Take a
Timing item 12 for motion.
Wait, your lordship. Before your lordship, we start, kindly see the annexure.
Where is the opinion?
Opinion is that page lordship
67. Lordship, kindly see page 70 and 71, Lordship, before that. Because there
No,
is some
no.
error in translation.
Whatever be the error, let us see the opinion first,
Yes.
which is page
Page 67,
67.
Annex 14.
67 is 2019.
Yes, Lordship.
No,
I'm challenging
we
that.
will not look at any other document. You first explain us delay and latches. Why it should not be, your petition should not be dismissed.
Check,
Where is your pleadings for delay of 6 years in coming to court? Where have you explained that?
there is explanation, Lordship. Coming to that. Para 27 at page 14.
This is no ground. Now tell us why we should not dismiss your petition at the motion stage on the ground of delay and latches alone.
Well,
Because Mr. Sharma,
yes, Lordship.
you can't possibly make a argument that you lost contact with your counsel. The reason is you come to page 67. Page 67 is the opinion. In the opinion, your name of your counsel is written.
Yes.
How can you say that you lost contact with your counsel? Counsel is not ordinary people like us. One can forget.
Which means that, Lordship, this copy was obtained on 26 May this year, Lordship.
Pardon me?
This copy was obtained on 26 May of 25, Lordship.
No, whenever it was obtained,
Therefore, then uneducated man, therefore he did not retain his contact. And this copy was obtained by the somebody else. Not by their advocate. Lordship, on this delay point, I want to make my submission on with some authorities. Lordship may take up the matter day after tomorrow, if it is not inconvenient to the court. And Lordship, one more thing I want to point out that there is some mistake in translation, page 70. So I want to correct that also.
page
70, Lordship.
70.
70. Because at page 71, the name was written as Rojavali said, and his father's name was Thasbali. It so appears like it is Thasbali like that, but the translation was wrongly done as son of Hussein Ali. So this is a major mistake, and I don't want to pursue the matter with this mistake.
Okay. All sides are represented. On the court query as to the is to the maintainability of the writ petition on the ground of delay and laches. Mr. R. Sharma and counsel for the petitioner prays for some time to address the court. Full stop. He has also submitted that. Next paragraph. He has also submitted that there is a typing error. That a typing error has crept in the translation made in page 70 of the writ petition. Full stop. Accordingly, he is granted liberty to bring a correctly typed copy of page 70 in record by handing it over to the AOJ FT section for being inserted in the writ petition. Next one, a list on
In the next week, in the next week.
next Monday. It will be
Yes, sir.
9/6. Okay.
What's it 9/6, maybe on 11/6 also.
11/6. Okay. Make it 11/6.
Obliged.
Upgraded item 74 for orders.
Typing
Where is the order of the Supreme Court?
Yes, my lord. It is at page, my lord, 8, my lord. It starts
8 of
from-
the IA.
Yes, yes, IA, my lord. Fresh IA, my lord. IA 565 of 25, my lord. Well, I prepared a list of dates just to.
Yes.
So, my lord, the paper books is of course ready, my lord, and it has been served upon us also. But the somehow the case was not listed, so it could not be taken up on board, my lord. So in the meantime, there is a Supreme Court order, my lord, and the relevant para is at that page 9, my lord. Roman 3, my lord. Shall I read, my? In the event the appeal cannot be decided for some reasons or the other during the next 6 months, it shall be open to the appellant, that is accused, to make a further prayer for extension of interim bail granted hereby before the High Court, which shall be considered in accordance with law. So that's why I'm before your lordship now, because very recently, my lord, I have taken.
Extension of bail can only be granted by the Supreme Court now.
No, they have given the direction, your lordship. That is what is there, my lord. I can renew my prayer before your lordship, my lord. It shall be open to the appellant to make a further prayer for extension. Prayer for extension is before the High Court, granted hereby before the High Court, which shall be considered in accordance with law. Because if the appeal could not be heard and disposed of within 6 months for some reasons or the other, then Honorable High Court has been
This
granted.
was
That is
never
what-
brought to a notice.
That is why, Lordship, may I submit those? In the morning, we have prayed for adjournment only one day. Now, Lordship is taken this matter, Lordship. Kindly perish the whole order of the Supreme Court, Honorable Supreme Court. We are abide by the Honorable Supreme Court's order, Lordship.
No, just a moment. You see, number one, whatever you have said, please pay some respect to the senior counsel who is on legs.
Due respect.
No. It should never be done. Unless he's standing, you should not interject a senior counsel. At least that is not expected.
I haven't completed it.
Then I'll submit later on.
Yes, please.
So, my lord, I have given a list of dates, my lord, wherein I have incorporated all the relevant dates, my lord, how this stage has come, my lord.
Yes.
So if your lordship will see, my lord.
No,
or
you
is
see,
it-
Mr. Kamal,
Yeah, my lord.
nothing to do with the prayers made.
Yes.
You see, we are now in the midst of a hearing of the
Yes,
APSC matters. So it's really not possible for us to take up a criminal hearing right now.
Right.
And since the order of the Supreme Court has been brought to our notice only today for the first time,
Absolutely.
we will fix some other day for the hearing.
Yes, my lord.
And your, in the event we are unable to hear the matter on that day, then we'll consider your prayer for
But
interdiction.
right now, I am in bail, my lord, and my bail will expire on the 3rd, my lord. Okay, ma?
Today's last day.
Or today is the last day, my lord. Supreme Court has granted me bail till today, and if in between the appeal could not be heard and disposed of, then liberty was granted to approach the Honorable High Court for extension. And Honorable High Court will pass the orders accordingly, my lord.
Where is the order of bail?
My lord, is that very order, page 8, my lord. Shall I read, my lord? The
Yes.
appellant stands convicted for the offence punishable under section 302 IPC. Post conviction, he has suffered incarceration for a little less of 3 years due to his minor's daughter ailing physical condition. She is a cancer patient. The appellant sought for temporary bail, citing that the child requests to be taken to Kolkata for treatment. He was granted interim bail. The High Court, by the impugn order dated 3rd August 23, extended the period of interim bail granted earlier to a further period from 8 August to 7 September. A direction followed that on 8 September, the appellant shall positively surrendered before the district jail Noga. Pursuant to the interim order passed by the special leave petition, out of which the criminal appeal arises, the appellant has been on bail since then. Keeping in mind the fact that the child of the appellant is suffering from a dreaded disease, as well as the fact that his wife is also 45% orthopedically handicapped and therefore not in a position to accompany the child for the purpose of a treatment at Kolkata, we have considered it proper to pass the following direction. Direction number 1, the appeal pending before the Honorable High Court, being criminal appeal number 391 of 2019, is expedited. The High Court shall make sincere endeavor to decide the same within 6 months from date. Till such time the appeal is finally decided, the appellant shall continue to remain on previous bail. So I am on previous bail till date. In the event the appeal cannot be decided for some reason or the other during the next 6 months, that is from the date of passing of this honorable Apex Court judgment, my lord, order on December 2. The next 6 months it shall be open to the appellant to make a further prayer for extension for the interim bail granted hereby before the Honorable High Court, which shall be considered in accordance with the law. The appeal stands disposed of on the aforesaid terms. Pending application, if any, stands disposed of. And the next is the preface, my lord. And in the meantime, I have taken my daughter to the Bhubaneswar Bora Cancer Hospital, my lord. Her date is given on 9/7 for further review. And if your lordship will kindly see the cancer patient's health, my lord, at page 18, the daughter is 13 years. As on
From
today,
the
she is,
reports, from the reports annexed,
yeah,
it doesn't,
Page
doesn't
8.
seem that the cancer is not cured.
not cured.
It doesn't appear.
No, page 18, my lord. Okay.
Page
We-
18.
Yes.
Yes.
If your lordship will see final automated complete blood count report, my lord, these are the things which platelets. If your lordship will see it's higher side 11.80, such is the thing. I am also not a medical expert, my lord, but from there it is seen from the it can be seen from the chart, my lord. The 2 blood counts are low and 2 are high, my lord. And above that, he has become psychological psychiatrist problem also is there. So if your lordship will also read
This,
together.
the psychiatrical problem which she is facing is now creeping up in most of the homes.
Yeah, absolutely. That's true. I don't
This is-
understand this line, my lord. Significant improvement in phone users timing.
Yes, this has become a menace to the children. They start playing with the mobile.
I have got it first time, my lord. I'm
No,
not.
I have seen it. I have seen patients, young boys and girls in the hospital because of that. They every time they play with the mobile
Right.
and they become so hyperactive.
Addict.
Not addict. They
Then?
become hyperactive and
Acha, acha.
they become what you call. There is a syndrome. I forgot the name. It is they are always filled with anger.
Ah,
They want to kill people. They want to shoot down people, and therefore the anger management.
absolutely.
First is
It's
phone
written
management.
there.
One is phone management. Then there is an anger management. You don't give them phone, they want to kill even parents.
It has happened. We read often. So here it's written, as your lordship has said, note much improvement in concerns of anger. Behavior modification suggested for last session.
This
to
is
be
only because now we are in modern times. We don't give corporeal punishments to our children.
Children, yes.
One corporeal punishment and the children will be all right.
When she is actually a cancer patient, the parents also wants to keep her happy. So in the process, maybe
In the process, this has happened.
these are all behavioral changes happens, my lord. So my respectful prayer will be, your lordship, my lord, let a date be fixed and a convenient date, my lord. And in the meantime, I may be allowed to remain on bail so that I can take treatment of my daughter by taking her for further better checkup in Kolkata. She is already undergoing treatment there in the hospital, Calcutta Hospital to Namasan.
But the continuity of the diagnosis of cancer is not there.
My lord.
That she's suffering from cancer is not available from any of the medical
So
documents.
that is the only medical document right now I could see, my lord, that she has been taken to the hospital and that behavior.
Wasn't
This page 15 is something.
page
regarding-
14?
Yes.
Page 14 shows
Yes.
almost negative.
No, I've barely given the document.
No, that's okay, but
So I pray that Lakshman may be given for his daughter's treatment. In the meantime, the matter may be heard and disposed of as per law, the law. In the meantime, in between, any date after 1 month.
yes.
Lordship, there is, from the record, it reveals that there is no urgency of the applicant's prayer. Lordship, kindly peruse the Honorable Supreme Court's order is dated December 2, 2024. Was passed and directions were given.
Just a moment.
Page 8. Page 8.
Yes.
Page number 9, the date is mentioned December 2, 2024. And by this order, Honorable Supreme Court, Apex Court directed, Lordship kindly peruse paragraph 6 of page 9. The appeal pending before the Honorable High Court being criminal appeal number so is expedited. The High Court shall make sincere endeavor to decide the same within 6 months. Now, Lordship, without communication of this order to this Honorable Court and the other side, that is the informant. So they came before this Honorable Court on 2/6, on the last date after, on the 6 months expiry. Now, paragraph 2, till such time the appeal is finally decided, the appellant shall continue to remain on interim bail. Paragraph 3, in the event the appeal cannot be decided for some reason or the other during the next 6 months, there is, Lordship, after getting the Apex Court's order, they have not filed, this petition was filed on 28/5, Lordship. And this copy has been served on us 28/5. After 6 months. So, Lordship, they cannot say that the Supreme Court's order is there, so we came here to extend the interim order, Lordship. And from the medical report and the approach of the applicant, Lordship, it is not shown that they are in urgency, Lordship. Now, Lordship, these persons is a convict of 302, life convict,
And there are several earlier petitions also filed for interim bail application. And he is in interim bail since many months, Lordship, years, by extending after extending, Lordship. Now, this is the clear disobedience of the Honorable Supreme Court, because Honorable Apex Court given him the relief, but they were not used the same. So I pray, Lordship, as there is direction that was, today is the, after 6 months, due to the lapse of the applicant, Lordship, fix this matter on tomorrow or 2-3 days after, and final hearing may be conducted, Lordship. He cannot be outside by taking extension after extension.
Yes,
Lordship.
what do you have to say?
Lordship, as the paper book is ready, Lordship, the matter will be fixed for final hearing, Lordship. And then fixed date may be given, Lordship.
We are right now on the interim application, please. What do you have to say on this interlocutory application?
Body treatment of it, I can.
Lordship, as regard that, Lordship, my learned friend have said, Lordship, that the time is expired, Lordship, and they had not informed the court, Lordship, regarding this, Lordship. They have filed a fresh petition regarding this.
I humbly submit to that, my lord, that there was no such direction that I should inform, my lord. And if they were aware, they should have approached the courts, my lord.
Lordship,
Because there was no direction as such, my lord, that I have to inform.
in the Honorable Supreme Court, it is the duty of.
Yes, explained you about the decency in court.
I'm sorry.
What, sorry, for the second time we are telling you, and you are disrupting when Mr. Kamar is speaking. You are not aware of his status as a senior counsel? Then
My intention was not that.
what's the question of intention when you are disrupting the court? We'll extend the bail only for your conduct. We are making it very clear, when a counsel speaks, you don't interrupt. And when there is a senior counsel on the other side, there's one more reason not to interrupt. Because of your conduct, we are granting bail. We started with a negative by asking the senior counsel the same question. And then you interrupt for the second time. Message should go very clear to the bar, members of the bar. You are not to disturb when a counsel is on legs. If you don't have a decency, don't interrupt. You could have requested Mr. Kamar to for leave to address the court. No, you're not sorry. Just because I have vented my anger, then you are expressing your sorry. It's not the manner. For the second time, you have been told not to disrupt. On the first occasion, you should have learned a lesson. People make mistakes and learn from it. You have made a mistake and don't learn from it. We are granting 2 weeks time because we are in the midst of a hearing of a matter. We can't devote time for hearing of a criminal appeal right now. But we'll record in the order that the Supreme Court order has been placed before us for the first time, only today.
That definitely. And normally the registry sends it to our registry also, my lord.
We don't know.
Hey, that's why I'm not saying anything.
We don't know. Heard. Mr. Z. Kamar, Learned Senior Counsel, assisted by Mr.
K.D. Sharma.
K.D. Sharma, Learned Counsel for the applicant. Also had Ms. N. Chaudhary, learned counsel for the private respondent. Number 2, and Ms. A. Begum, learned AVP for the state. Next para. By filing this interrogatory application, the applicant, who is the convict, by judgment and sentence dated 28/8/2019, passed by the learned additional sessions judge, FTC, Ojai, Shankardev Nagar, in sessions case number 59 of 2015, and the appellant in the connected criminal appeal number 391 of 2019 has prayed for extension of bail, which was granted to the applicant by the Supreme Court of India by order dated 2/12/2024, passed in criminal in SLP within bracket criminal number 10927/2023, page 8. Full stop. Next, they said order of the Supreme Court of India is quoted below, page 8 and 9. Next, by referring to the medical documents annexed to the rate petition, it is the learned counsel for the senior counsel for the applicant has submitted that as per instructions received by him, the girl child of the applicant is still taking treatment for cancer at Kolkata. Most of it is further submitted that
Presently at B. Burwa, my lord. But presently at B. Burwa, but review and all these things are Dr. B. Burwa Cancer
at B. Burwa Cancer Institute at Guwahati, and has to
for final checkup we may go to
for
Kolkata.
review checkup. She's required to be taken to Kolkata. Most of it is submitted that the said child is also suffering from certain psychosocial PSYCHOSOCIAL disorder with behavioral modification Most of it is also submitted that the wife of the applicant is 45% orthopedically handicapped and therefore not in a position to accompany the girl child during medical treatment. Next page, it is also submitted that the Supreme Court of India has provided that if the connected appeal cannot be decided for some reason during the 6 months from the date of the from its order, it was open to the applicant to make a prayer for extension of bail. Next paragraph. Prayer for extension of bail is opposed by the learned APP as well as the learned counsel for the applicant. On the ground that though the order of the Supreme Court of India was passed on 2/12/2024, but the said order was not brought to the notice of this court in the connected criminal appeal. So as to enable this court to make an endeavor to dispose of the connected appeal within 6 months from the date of order of the Supreme Court of India. Next paragraph. We take cognizance of the fact that although the order dated 2/12/2024 was passed by the Supreme Court of India in SLP criminal number 10927/2023, no attempt was made by the applicant to bring this said order to the notice of this court so as to make an endeavor to dispose of the connected appeal within 6 months time granted by the within 6 months as envisaged by the said order dated 2/12/2024. Next paragraph. This bench is in midst of hearing a parted a series of parted matters which is being taken up on day-to-day basis, consisting of 51 writ petitions. So therefore, the hearing of the connected appeal cannot be immediately taken up. Next paragraph. We would also like to put on record that for the first time today, the order dated 2/12/2024 passed by the Supreme Court of India has been brought to the notice of this court. Full stop. Therefore, being not aware of the said order, no endeavor was made by this court for an out-of-turn hearing of the connected appeal. Next paragraph. Be that as it may, separate orders are being passed in the connected appeal for listing the matter for hearing. Next paragraph. Be that as it may, as the applicant is on interim bail, the court is inclined to extend the said bail till the next date of listing. Next paragraph. List on. Just give a. We'll see the date after some time. And in the connected appeal, you say all sides are represented in view of in light of the contents of the order dated 2/12/2024 passed by the Supreme Court of India in SLP criminal number 10927/2023, considering that the paper book is ready, the court is inclined to direct the matter to be listed for hearing on Okay, 12/6/2025.
Much of it.
The bail order extended till 12/6/2023. Oh. Which there are connected appeals also in these. Here's another here. Thank you.
Two.
Yes.
My lord, the order, my lord, interim order passed by your lordship is at page 8, my lord, of my lord I.
Yes.
By order dated 14/5, my lord, your lordship has, my lord, allow interim order, operative part at page 10, my lord, para 7.
Okay, so what has happened?
My lord, thereafter the petitioner went to the office of the, my lord, SP border Borpeta, my lord, and she was intimated that all the records has been sent back to the newly constituted, my lord, Bojali district, my lord. Therefore, my lord, impleadment of.
Okay, we allow this order and we extend time for the petitioner to appear before the president. Mr. N. Sarkar and counsel for the petition. Applicant. All the respondents are there. This court by order dated 14/5/2025 granted interim bail to the granted bail to the petitioner on certain conditions. Comma, which was passed in connection with the connected WPC 563 of 2025. Next para, the learned counsel for the applicant submits that when the petitioner approached the Superintendent of Police border Borpeta, comma, she was informed that all the records have been sent to the Office of Superintendent of Police border Bojali at Patshala in view of change of jurisdiction. Your residence is within Bojali.
Yes, now my lord Bojali.
As the residence of the petitioner, which was earlier in Borpeta district, now comma now falls within the within Bojali district. Full stop. Next, but accordingly, comma, the applicant is prayed for impleading of the Superintendent of Police border Bojali as respondent number 8 in the connected writ petition. Next paragraph. Having heard the standing counsel for the FT matters, the court is of the constitutional opinion that as the authority to grant bail is the Superintendent of Police Border Bozali, the prayer made in this interlocutory application is allowed. For impleading the Superintendent of Police Border Bozali as respondent number 8. Next paragraph. Accordingly, the court grants additional 10 days time from today to appear before the Superintendent of Police Border Bozali and to furnish a bail bond of rupees 5,000. And to comply with other conditions as contained in the order dated 14/5/2025 passed by this court in WPC, in the connected WPC 563 of 2025. Next para, in the event the applicant approaches the said authority within the time allowed, the Superintendent of Police Border Bozali shall do the needful in terms of order dated 14/5/2025 passed in WPC 563 of 2025. Next part, this order shall be read together with order dated 14/5/2025 passed by this court in WPC so and so.
Much of.
This I stands disposed of. And in the connected writ petition, you say both sides are represented in view of order passed today in the connected IS Civil 1696 of 2025. Land counsel for the petitioner shall provide a amended copy of the cost title to the AOJ FT section within 3 working days to so as to incorporate the same in the writ petition. Next para. For the last paragraph, the registry is in receipt of a letter dated 19/5/22, a letter number. This is a flag X, this one. Flag X, last flag X. Number so and so dated 19/5/2025 from the Superintendent of Police within bracket border, bracket Borpeta. In this regard, there's no cognizance of a letter can be taken by the court, the Superintendent of Police Border Borpeta shall be well advised about the manner in which he would put forth his prayer before the court. Next paragraph, the learned standing counsel for the FT matters shall communicate a downloaded copy of this order to the Superintendent of Police, Borpeta, Border Borpeta. He has sent a letter that the records have gone to Baksa. Therefore, we have said he may be well advised in to.
Lordship, one small aspect, Lord. A respondent number 5 may be correct. Respondent number 5, it was edited Deputy Commissioner.
Oh, acha. Then also say that. That before this amended copy of cost title, before that, the nomenclature of respondent number 5 does not exist. Therefore, the learned counsel for the petitioners shall implement an appropriate party as respondent number 5 instead of the present authority. Same there after that, this 3 days, same. Only this thing can be added. We amend that also. We continue at 2. Yes, you are here. For what reason? WP criminal. No? We'll take it up at 2 o'clock. This one. There's a meeting right now. Yes.
But rest of the admission matters will be.
They'll be all rolled over because we'll take up those APSC matters.
So any fixed dates are given for X.
If you have some urgency, tell the court master he'll accommodate. If you have no urgency, then he'll not accommodate.
No, I have the stay order until further order.
Last 6th,
Yes.
June 2025. 6K. Okay, we allow your mention is allowed.
Deeply.
Some other day, 6th.
Not 9.
9th. 9th.
Nine. Okay.
Deeply.
Repeated item 18, WP criminal 18/25.
Oh, acha. Pursuant to our earlier orders, this has been re-registered as a criminal repetition. Because of the fact that saying that the allegations are that the husband of the petitioner disappeared from police custody.
Affidavit has been filed. They have also filed a reply. They have filed a reply.
So, in view of the re-registration as criminal repetition, you are comfortable with your affidavit?
Malad, I'll go through. I'll go through.
Hmm?
I'll check the record.
No, I'm just asking a question because I'm required to.
Logic, yes, logic.
In a
Logic.
criminal repetition, the standards are a bit different.
Different. Lordship may keep the matter after a week. I'll in the meantime I'll go through.
Okay. There's no representation from the petitioner. However, Mr. D. Nath, Lanet, government advocate, is present. Next para. pursuant to order dated 11/12/2024, the proceedings of WPC 6582 of 2024 has been re-registered as WP within bracket criminal 18 of 2025. And accordingly, the matter is listed today. Next, Baba. In view of the re-registration of the same writ petition as a WP within bracket criminal, Mr. D. Nath, Lanet, senior government advocate, prays for some time to examine whether the affidavit filed by the state would be sufficient and adopted in this renumbered proceedings. Post on. Next, accordingly, matter stands adjourned today. List on.
Lordship may keep it in the second week, malad, on 16 or 17. Malad. After the second.
Okay, 17/6/2025.
17.
I think. Conclude you. Mr. Nath, item 13.
Yes. Malad, on last occasion on 16/5/25, Lordship has directed us to take the status report of Khatkoti PS 291 of 2012.
Yes.
In fact, Lordship may kindly, I have received the status report, Malad. The status report says that already after the investigation was directed, Malad, it was investigated and the FR has been submitted. And Malad, this development was in fact apprised to the Honorable Court earlier. Lordship may kindly take up order dated 7/8/23, Malad. 7/8/2023.
No, 7/8/23 records.
Yeah.
11 years have passed and the investigation is still going on.
Lordship. And subsequent to that,
in category PS case.
It was observed on that day.
No, on 11/8, it's reported that the charge sheet was final report was submitted in this case on 30/4/2023.
Yes. True. And on that day, Lordship has directed us to directed the IO to remain personally present on the next day. Then kindly come to order dated 38/23. 38/23. On that day, the final report was indicated, Malad. And Lordship has allowed us to file the final report on record in the form of an affidavit. That affidavit was filed, Malad. It is on record.
That's it.
Affidavit on dated 8/9/23.
Is the case records available with us?
Well, the FR we have already annexed in the affidavit dated
No, in this letter you have produced, it says that the case diary is available with us.
No, in the court, in the law court,
Acha, Kachar Shuchar,
in
okay.
the law court.
Okay, okay.
Lordship. The FR copy, the certified copy we have annexed in the affidavit. It was filed in the month of September 23. The IO has filed the affidavit.
So we'll have to call it from the concerned court. Records of Katikura PSK.
Yes. If Lordship wants to see the record. Otherwise, if Lordship takes off the affidavit of respondent number 5.
May I please your lordship? May I please your lordship? We have filed additional affidavit, lordship. That FR has been rejected, lordship, and we have annexed that order, lordship.
You filed when?
Last Saturday, lordship, just Friday. Recently filed.
Last Friday.
Yes, lordship. That it is
61.
That FR has been rejected, lordship. Order annexed, lordship.
Okay, page 167.
No.
But then after 2015, after 10 years, we are back to square one. Because if reinvestigation has been ordered, then perhaps in the rate petition we can do nothing.
No, in the FR, they have annexed the order. If kindly come to page number 169. 169, Annex C.
69.
Yes, Lord.
169, Lord.
It is their affidavit in reply. Honorable Court has said that considering the materials available in the case diary and considering the contents of the objection petition, the FR submitted by the IO is not accepted. Let a complaint case be registered on the basis of the objection petition, which shall be filed on the next date fixed. So now a complaint case has been registered. So
complaint case to register hobo.
So my respectful submission is, Lord, the last order indicates that what is the status of the investigation of the 2012 Katkoti PS case. That, my lord, we have already apprised that earlier FR was submitted and Lordship has directed reinvestigation. It was reinvestigated and FR has been submitted. Now it is before the trial court and the trial court has not accepted the FR. A complaint case has been registered. That is the position as on today. Three five what you want.
167 or 167? Encouragement to get some good evidence to our comparison of section 50-50. It is the finish.
Mr. Dekar, then you see, after a complaint case is registered, then perhaps the trial will go on. So in this writ petition, the relief which we can give for the death of the person during his jail custody would only be as per the government notification, nothing more, because we can't now say that who is at fault or what has happened.
Yes, my lord. And for this,
So,
but on this point, my lord, in the 2023, my lord, the developments of the Meghalaya High Court, my lord, relying on 2017 Honorable Apex Court judgment, my lord, if you lordship permit me, my lord, and there's a PL, my lord, but discussed all this issue, my lord, the Indian, and so far as natural death or unnatural death is concerned, my lord, if
no, if you want to cite decisions, even if we are with you,
and where, my lord,
Well, in fact,
in the writ petition, we made two prayers, my lord. And the first prayer, my lord, to investigate the entire by the independent authority or the adequate
that we can't do
compensation.
because the trial court has taken
Yes, my lord.
cognizance of
That part,
the
that was answered, my lord.
so
That
that's
was-
gone. The
Yes,
second thing remains is compensation.
only, my lord.
Then,
only that part remains.
so then we'll, as per your notification of, we have to give compensation, that's all, and close the matter.
Yes, my lord.
Well, in fact, I would like to refer to the reports available, the medical reports, the affidavit of the doctor, all are available before your lordship.
No, even if he commits a suicide, but it was within a jail campus.
No, it was because of his illness he died. The report suggests.
No. He was in the jail. Sorry, he was in police custody at that
He was
point
in
of
the
time.
police custody because of his chronic
And then
illness. my lord,
because
he
of
died.
his heart ailment, when the witnesses say that he was assaulted, his neck was turned.
It is their case. my lord. It
No,
is their
it's okay. But the death occurred when he was there because he was brought dead.
in the custody. lord.
So when he was brought dead, on that point,
ঠিক আছে।
the person was in police custody. That's no escape to that. Whatever has happened.
Well, keeping aside the allegations and the whatever they have stated in the petition, that to that extent, my lord, I can't deny.
Because once the trial court is in session of the matter, we can't say what has happened.
That's
That has to be kept open.
That's true. That's true.
You have a copy of the circular of yours?
My lord,
Copy of the circular for compensation?
circular copy, my lord, I
Last time you gave it.
I have, my lord, once I have mailed it to the court master also. I have a copy in my. I can give it.
Please resend it again.
Yeah, I'll
does
send
it?
it. I'll send it.
It's the assessment, CG resident. Circular notated. Quotation 18. Point so, point, satisfying circular notated.
We'll try to check. It must be available here. Once you have sent by mail.
I have copy. I'll also send now. I'll also give copy. I have it. When compensation or when the inner Yes. This will কথা বলে দিব লাগিব। পানি দিম। মোৰ আছে আছে।
পঠাই দিছে নেকি?
মই এতিয়া পঠাই দি আছো।
সেইটো ভাল।
এতিয়া আছে।
We are taking up on Friday. Let us go through the records. We'll go through it and then we'll form our opinion what to do.
Yes, not.
In the meantime, we'll get that also.
I'll submit a copy.
Also is a represented.
I'll take printout and submit.
We get a counsel for the petitioner has referred to the contents of the additional affidavit filed on 29/5/2025. Stop on a perusal of the same. It appears that the final form submitted by the IO in connection with Katigora PS case number 291 of 2012. Corresponding to GR case number 2363 of 2012.
Yes.
This was corresponding to was rejected. So consequently, it was rejected by order dated (23/4/2025) passed by the Learned Chief Judicial Magistrate Kasar Silchar. And a complaint case was ordered to be registered on the basis of objection petition filed by the petitioner. So the complaint case has been registered. Has the complaint case been registered?
My lord, and next date on 10th of July. Before that, we'll file a complaint case, my lord. Next date fixed on 10th of July, my lord, 2025. Before that,
I don't get it.
My lord, next date fixed on 10/7/2025. In the meantime, we'll file a public.
Okay. First of it is first of in this regard, the Learned Counsel for the petitioner has submitted that as per instructions received by him, the next date
10/7/2025.
Next date of the matter fixed before the Learned Chief Judicial Magistrate is 10/7/2025, and the petitioner proposes to file a complaint case prior to that.
Yeah.
First of- Next view, in view of such circumstances, I propose to take up the matter again on Friday.
Not.
on 6/2025. Was from list accordingly.
No, only one aspect, Malad. Here the son is the petitioner, and their objection has been filed by the wife, possibly wife,
My mother, Milord.
Mother.
the wife of the
Which is
deceased.
not objection not by the petitioner, but the mother
My
of
chief's
the
wife, Milord.
Lord.
mother of the deceased.
Deceased.
No, the wife
Wife of the deceased.
of the
Oh,
deceased.
sorry, wife of the deceased.
Here son is the petitioner.
Lord.
Lordship. Oh, okay.
ये तो बाद में आएगा। Just not telling uncase in the age of high speed IPO.
Which matter you want us to take us first?
Lordship may take the writ appeal
128.
128. Kunal Das.
Yes.
Lordship. What I was proposing, Lordship, in terms of my arguments, how I've structured it, is today I plan to give Lordship the very basic facts. I will show a certain order that includes all the facts that I could otherwise argue from the files. Then, Lordship, I will show a very brief chart, which is really a compilation of all the writ petitions and just putting down the basic details. We've compiled that. And Lordship, then what I will do is I'll refer to the case of Kunal Das for a reason that became the lead case before the learned single judge for us, as far as the state is concerned. And in that, Lordship, we had filed all the relevant documents. The service rules, everything is there. The appointment letters, the discharge letters, they are all in that one compilation. I may also point out, Lordship, at the threshold, I will show what were our arguments. And I hope to finish all that today. Before the single judge, so basically very short, crisp, this is what we argued. And finally, time permitting, come to what are our arguments here before Lordship's bench in the appeal. I will then, Lordship, over the next, hopefully 2 days, which is what I'm targeting, or maybe a third day, take Lordship through the legal propositions then in support of those facts. And I will then rely on the judgments. And at the end, I may require briefly to allude to individual cases, because I would believe broadly we would have covered everything in the sweep of the arguments that I'm putting forth. I must point out at the threshold, Lordship, one thing, that an argument had been brought that we have brought an additional affidavit through an order of the learned single judge. Of course, Lordship, that order was never challenged. That affidavit was filed. However, why I'm also relying to Kunal Das is that in Kunal Das, at that point of time, an affidavit in opposition had not been filed. And the stand in this being the affidavit in opposition is the stand also that reflects in the additional affidavit, the other cases in which affidavits of opposition till that point had been filed. So it's not as if the state has changed its stand. The state has broadly the legal principles on which we had argued before the learned single judge. We had enumerated all of that in our affidavit on opposition. That's duly recorded here. So I'll just take Lordship through that. Basic facts, Lordship. 52 petitioners in 48 writ appeals, 29 ACS, 11 APS, 7 tax, 2 labor, 2 transport. The 2 exams are 2013-14. 2013 batch exam becomes 2015 batch. The result is then. And 2014, the result is in 16. So that becomes the 2016 batch. Now, Lordship, when I look at the numbers, 2,553 candidates sat for the preliminary examination, Lordship. 42,553. It's a fairly large number. 2,287 cleared the preliminary, sat for the mains. And finally, 497 were called for the interview. 241 were selected. So therefore, Lordship, when I look at this figure of 42,553 versus the final lot of 241, for every person who made it into the civil service, 176 people were approximately unsuccessful, over 175. That is the extent of the competition. And Lordship, in the same figures, if I give it for the 2014 batch, 14 exam, 24,722 sat for the prelims, 1,550 made it for the mains, 371 were called for the interviews, and 180 got selected. In that batch, the ratio is 1:137. Therefore, Lordship, if we only look at the basic numbers, for every one person who gamed the system, and I'm using the word gamed the system, enabled their entry through a taint or by perpetrating a fraud onto the entry point, at the entry point, they ousted the chance of 176 bona fide applicants or aspirants in the 2013 exam and of 137 in the 2014 exam. And this is a factor also, Lordship, just in the sheer numbers. This is not a case only of an individual here and there. When we make our arguments, we believe that, Lordship, this is also a factor that has to be considered when an argument on Article 14 is professed. Because there is the rights also of those bona fide aspirants who got left out because of the manner in which these specific candidates, with the connivance of the then chairperson of the Assam Public Service Commission, had replaced their answer sheets, got the invigilator's signatures, replaced into the board strong room, etc. They had taken it. Lordship, the applicable rules, only as a reference, I'm not referring to it yet. The probation, the fact to be made is that every one of the appellants here were probationers or temporary. There's not one person who has been discharged who was a permanent employee. Not one of them whose services was confirmed or a satisfaction had been given in writing on the day of their discharge. Because that would be the first legal principle on which I would be building the case law. This chart, Lordship, which is a summary, the applicable rules, Lordship, we just note because I'll be dealing with probation. For the ACS, it is Rule 22, Lordship. For the APS, it is Rule 15 read with Rule 17. For tax, it is Rule 21. For transport, it is Rule 21. These are all qua the probation. And for labor, it is Rule 12 read with 14. Wherever there is a read with, it talks about the next level, that a confirmation requires a positive act in terms of the satisfaction. I'm just sharing, Lordship, a short chart because this is the summation of the case before Lordship. एक आध आपको भी दे दो एक्स्ट्रा कॉपी है व्हाट्सएप व्हाट्सएप सॉरी व्हाट्सएप वो यही हो रहे हैं सारे विल जस्ट व्हाट्सएप ड्रॉप कर दो Lordship, ladyship would have that chart. This table, Lordship. 1 minute, Lordship, may come to the last page, which is serial number 52. That's a little different. So I just want to flag that. On the 4th page, Lordship, which is writ appeal number 27 of 2024. Mrigan Halloy, Lordship. Agricultural Development Officer. Lordship may just see what is written in the comments. He was accused in the Bhangagad police station, case of 159-2 of 2017. He is convicted in the special case number 5 of 17, and a criminal appeal 263 of 2024 is pending. There was no suspension of sentence. So therefore, Lordship, this one is a case of conviction. So I just wanted to segregate this from the balance 51. And Lordship may also note that all the others, which is serial number 1 to serial 51, are accused in the FIR 936 of 2016 of Dibrugarh. He is of the Bhangagad FIR. Right, Lordship? So Lordship may just see what this table is there, just as a convenience. The serial number, then we have the writ appeal numbers, Lordship. We have the name of the appellants or the accused persons, Lordship. We are talking of the departments and the service, Lordship. And then finally, what is their accused number in terms of the charge sheet, Lordship? Then it talks of the date of arrest, Lordship. It talks of the charge sheet number. And finally, the date of the charge sheet. This is just the data, Lordship. But the point we are making on the basis of this data are two. The first being, all of them were arrested between 3rd of May 2017 and 23rd of July 2018. So the arrests of all these probationers is between 3rd of May 2017 and 23rd of July 2018. Lordship may just mark that the Dibrugarh FIR was of October 2016. So approximately 7 to 10 months later, the arrest started based on the investigation and continued up to July 2018. They are all covered, Lordship, in supplementary charge sheet number 1 to 6. All of them. The charge sheets were
Dibrugarh FIR was on
27th October 2016, Lordship. FIR 936 of 16.
arrested between
3rd of May 2017 up to 23rd of July 18. They are all named as accused in supplementary charge sheet 1 to 6. And Lordship, the date of the filing of the charge sheets is between 28th of July 2017, 28/07/2017, and 14/09, that's 14th September 2018. So basically, Lordship will note that once the arrest starts, the charge sheets also are following fairly soon thereafter. There's no per se delay on that. They were all probationers. Now, Lordship, what I'm going to respectfully do is read one order which encapsulates all the facts that I would otherwise be showing different documents and arguing from. That, Lordship, is the order of framing of charges and it's dated 19th of April 2022. 19th of April 2022. I won't read the whole thing, Lordship. I'll read parts of it and then come to the. Now, why am I showing this, Lordship? One, Lordship.
This is a part of pleadings here.
But Lordship, it's a court order. So, I mean, it's not even, I'm not making. So, therefore, I'm only merely showing you what is the factual court order. That's all. That's fine.
Because they
I mean,
will not be instructed on that.
Lordship,
Okay,
at least subject to correction. Court orders we just show over the this. But however, if there is a practice that requires us to file it, we'll do that, Lordship. That's not an issue. So, it's also, Lordship, a matter of public knowledge. It's not anything out. Lordship, there are 4 things that I wish to basically just through this order show. Number 1. As my colleague was pointing out and he reminded me, Lordship, we had also placed it in the predecessor DB also when we had once brought it. So it's not as if we are bringing it up the first time. Lordship, I'm showing it to cover the basic facts because in 4, 5, 7 paragraphs, he covers all the basic facts. Then, Lordships, I will also through this order show that many arguments that are being professed by some of the appellants here are the identical arguments being professed in the criminal court during trial. And Lordship, they have been seeking discharge. That has been, of course, rejected. And therefore, Lordship, from my perspective, it comes that I ask myself the permissibility of raising an argument that can be taken in the criminal court being brought into the writ jurisdiction. Because there is a totally different proceeding altogether. How can the issues related to discharge and the criminal proceedings be argued in an appellate proceeding in the writ jurisdiction? So that was the basic, but it gets covered here. Lordship may just open the order if I can take Lordship and Ladyship through the order. 19th of April. This is special case number 2 of 17. Para 3, Lordship. Today the case is fixed for passing order on charge and the order is passed as follows. Now I'm coming to the basic facts. From the case record, it appears that on 27th of October 2016, the informant Dr. Anshumita Gogoi filed a written ejahar before the officer in charge of Dibrugarh police station against accused Naba Kanta Patir with an allegation that the accused Naba Patir contacted her and told her to pay an amount of rupees 10 lakhs to him to recruit her in the post of dental surgeon conducted by the APSC. He asked the informant to come to his residence located at Dibrugarh with demanded money on the day morning. Accordingly, she along with her close brother Arup Barkatkoti went to Dibrugarh. She had already informed the matter to Dibrugarh police regarding the conspiracy and demand of money by the accused. The police caught red-handed the accused Navakanta Patir while he accepted demanded money amounting to 10 lakhs from her. The informant came to know that the accused was running a network to carry out criminal activities to recruit people for government services in connivance and conspiracy with other persons. The accused met personally many potential candidates, took money from them in lieu of giving them government jobs of the state of Assam. Next page, Lordship. On the basis of the ejahar, a case at Dibrugarh police station bearing 936 of 2016 under section 713(1)(b)(d)(2 of Prevention of Corruption Act, read with sections 120B, 420 IPC was registered. During the course of investigation, with the permission of the court, sections 463, 468, 471, 477A, 201 IPC and section 13(1)A of Prevention of Corruption Act were added. On that day, accused Navakanta Patir was arrested and produced before the court. Subsequently, IO arrested all the names of the appellants are next. Then, Lordship, at the bottom of the page, 6 lines from the bottom, arrested accused persons were produced before the court and they were remanded to judicial custody. In due course of time, all the arrested accused persons were released on bail. The investigating officer examined several witnesses, seized lots of documents and articles, sent some of the documents and electronic articles to the forensic lab, Lordship, FSL, for forensic examination. and obtained reports, obtained prosecution sanction order under section 197 CRPC, and today section 19 of the Prevention of Corruption Act, and submitted charge sheet and 11 supplementary charge sheets. Lordship, as of today, Lordship, there are 14 supplementary charge sheets. That sense. So what is the then, Lordship, it says against the above mentioned arrested accused persons and one Rajiv Paul, Sudeep Das, one Rakesh Gupta, one Dr. Mrigen Saikia, and one Mufidul Islam, showing them as absconder. So Rajiv Paul, Lordship, is the absconding brother of Mr. Rakesh Paul, the then APSC chairperson. Then, Lordship, next paragraph, just one sentence. After taking cognizance of offences, court processes were issued against the accused persons. Bottom of the page, Lordship. Last para, accused Manas Pratim Haloi. Now that, Lordship may note, is writ appeal number 96 of 2022. Vide petition number 461 of 22 and petition number 518 of 22 filed under sections 227 and 228 of CRPC has prayed to discharge him as no prima facie case is made out against him. Lordship, later in the order, this is rejected. Then, Lordship, next paragraph. Learned Special Public Prosecutor, what is the state's case before the trial court? Prosecutor P.K. Bora, during the course of the hearing, submitted that the accused Rakesh Kumar Paul, being the chairman, accused Samedur Rahman and Basant Kumar Dole, being the members of the APSC, misused their position and power, illegally obtained huge amount of money from various undeserving candidates, and selected them for recruitment of various posts like ACS, APS, tax officers, DTO, etc. Accused Rakesh Kumar Paul, being the chairman of APSC, manipulated everything. He received money directly and engaged several middlemen to collect money on his behalf from various undeserving candidates. Accused Samedur Rahman and Basant Kumar Dole fully cooperated with him by manipulating marks of undeserving candidates. Accused Rakesh Kumar Paul printed duplicate answer scripts in the printing press of his brother Rajiv Paul, who is still absconding even today. During investigation, the investigating agency was able to recover fake answer scripts of various candidates from the house and rented house of accused Rakesh Kumar Paul. Okay. Now, Lordship, may just come to 5 lines below in connection of this. During investigation, the investigating agency was able to recover answer scripts of the arrested candidates and send the same to FSL for forensic examination, and the expert opined that the answer scripts were fake. The candidates volunteered to be approver. There are 3 approvers, Lordship. 3 candidates volunteered to be approver, and accordingly they were made approver, and they disclosed about the scam operated by the arrested chairman and members of the APSC. So, Lordship, what is the scam? The essentially, Lordship, is the touts of the then chairperson of the APSC, who are also some of them employees, reach out to prospective candidates for the exam. Those prospective candidates are asked to pay figures or bribes ranging from 10 to 40 lakhs, depending on the service into which they wish to get. So the highest rate, as we gathered from the investigation, is 40 lakhs, I think, is for ACS. And then it goes down the line. Those who paid the bribe, their entry was enabled through the fraud. How? They gave their exam. Their examination sheets went into the strong room of the APSC as per normal system. Then Mr. Rakesh Kumar Paul, being the chairman, having the keys to the strong room, took out the answer sheets. His brother printed duplicate answer sheets. Those answer sheets were brought, blank ones, in front of the candidates who rewrite their examination. And then somebody, and in most cases Mr. Rakesh Paul, signs as the invigilator. This then replaces this repeat answer sheet or fraudulent answer sheet is replaced, put into the strong room, and the candidates finally obviously make it. Therefore, Lordship, it is a colossal fraud. And our case is that we were able to, through a detailed investigation, identify each one of those beneficiaries. And the discharge is as per the rules. Let's move ahead, Lordship, to finish this order. Next page, Lordship. One argument I'm just showing that has also been brought here has been taken before the trial court. Just at the bottom of page 6, Lordship. Learned counsel so-and-so appearing for accused numbers so-and-so. His second last line, he has submitted that though the prosecution has claimed the answer scripts were printed at government press, but the government press authority in an RTI has clarified that no answer scripts were printed at the government press. This argument is reverberating in all places. The trial court has also here. Lordship may come to page 10. Again, I'm going to show an argument that is being taken at the trial court. During those proceedings, our arguments being taken here. Page 10, middle of the page, Lordship. It is the fourth para from the top. Learned counsel, Mr. Somnath Das. Has Lordship got that? Grateful. Learned counsel, Mr. Somnath Das, appearing for accused Manas Pratim Holoi, has filed a petition under section 227-228 CRPC with a prayer to discharge the accused. He has submitted that the answer script of accused Manas Pratim Holoi was not fake. The forensic report collected by the IO is not against the accused. The answer script was recovered from the house of accused Rakesh Kumar Paul, and it was found that 50 marks were added. If the marks were not enhanced, still he was able to get the job. He has then relied on various Supreme Court judgments. This argument also, Lordship, has been taken during the arguments here. Lordship, page 13. You've noted. Then, Lordship, page 13, third last para from the bottom. Merely says, I have carefully perused the decisions relied by the learned advocates. Next page, Lordship, 14. Basically, Lordship, on 14th, the last two paragraphs, the learned trial court judge is pointing out what is a charge sheet, charge, Lordship. And Lordship, next paragraph, Aram se. On perusal, the materials on case record and case diary, it transpires that on 1/7/2014, CCE main 2013 exam was started and the result was declared on 12/5/2015 and on 31/5/2015 CCE main 2014 examination was started and result was declared on 36/16. These, Lordship, are the dates of the examination. At the relevant point of time, the accused Rakesh Kumar Paul was working as the chairman and accused Dr. Samidur Rahman and Basanta Dole were the members of APSC. During the course of investigation, the investigating agency were able to recover written answer scripts with logo of APSC from the house of accused Rakesh Kumar Paul. The investigating agency conducted raid in the printing press of absconder accused Rajiv Paul, who is the brother of accused Rakesh Kumar Paul, and the investigative agency was able to recover 7 number of master paper of APSC answer scripts, 20 numbers of printed answer scripts of APSC, and 1 draft copy of APSC answer booklet. The house of accused Rakesh Kumar Paul, situated at Sri Mantapur, was searched and an amount of rupees 10 lakh, 11 numbers of written answer scripts of general English and general studies paper, 9 pages of tabulation sheets, which, Lordship, has been also covered we have in the proceedings, Lordship, of combined competitive main examination were recovered. The investigative agency has also seized several electronic items from the house of the accused. During the course of investigation, the house and the rented accommodation of accused Samidur Rahman and Basanta Kumar Dole respectively was searched, and the investigating agency was able to seize cash, valuable documents and some electronic items from the residence of the accused persons. It was revealed that accused Mehboob Ali Chaudhry was the PSO of accused Samidur Rahman, and accused Samidur Rahman used accused Mehboob Ali Chaudhry as his agent. and said Mehboob Ali Chaudhary searched the candidates who are interested for the recruitment of the government job, which are selected through APSC, and by collecting huge amount of money from aspiring candidates and thereby involved him with the scam. The accused Rakesh Kumar Paul, Dr. Samidur Rahman and Basant Kumar Dole allegedly manipulated the tabulation sheets and intentionally gave higher marks to the unsuccessful candidates and thereby selected unsuccessful candidates by depriving genuine one. At the relevant point of time, accused Pavitra Koi Barta was serving as assistant controller of examination of APSC, and he was the right hand of accused Rakesh Kumar Paul and helped him with all illegal activities of accused Rakesh Kumar Paul and other arrested members. Accused Abbas Ali Ahmad and Musarraf Hussain were also working as senior administrative assistants in the office of APSC. Accused Abbas Ali Ahmad, Musarraf Hussain and the absconder accused Raji Paul and Sudeep Das identified prospective candidates, enticed them and collected money from them on behalf of other accused persons with promise to select them in the examination conducted by APSC. As stated earlier, accused Navakanta Partir was caught red-handed while receiving bribe money from the informant. During the course of investigation, it was revealed that the accused was running a network to carry out criminal activities to recruit aspiring candidates from various government services in connivance and conspiracy with accused Rakesh Kumar Paul, arrested 2 members and arrested employees of APSC. In connection with the case accused of Dr. Mrigen Saikia, who was working as Subdivisional Medical Officer, Animal Husbandry and Veterinary Department, Government of Assam, was found actively involved with accused Rakesh Kumar Paul and other arrested members of APSC. He acted as middleman and collected money from prospective candidates. And then we come to the last para. It appears that accused, all their names are there, Lordship. All the appellants here may come to the next page, Lordship. And the sentence, which is about the 10th sentence from the top, Lordship, they received answer scripts provided by APSC authority. Has Lordship got that? Grateful. They received answer scripts provided by APSC authority. These answer scripts were received by candidates on their own signatures as per attendance list, as well as signed by the invigilator on verification on the day of examination at the examination hall. These answer scripts were brought to the confidential room of APSC office Khanapada and examined by the examiner as per norms and procedures and conduct of business rules 2010 of the APSC. Thereafter, accused Rakesh Kumar Paul, Pavitra Kai Barta, in connivance with accused Samidur Rahman, Basant Kumar Dole, Abbas Ali Ahmad, Musharraf Hussain, Mehboob Ali Chaudhary, with the help of absconder accused Rajiv Paul, Sudeep Das, Mrigen Saikia and Mufidul Islam, allegedly printed duplicate answer scripts and provided to the above mentioned arrested candidates in various subjects for rewriting the answer again after examination. This is how they get entry into the service. The accused Rakesh Kumar Paul and arrested 2 members forged the signatures of invigilators on duty in their duplicate answer scripts and gave marks by their own will to get selected the arrested candidates in APSC examination. Accused Rakesh Kumar Paul with his associates replaced the duplicate answer sheets and kept in the confidential room of APSC office Khanapada. Thereafter, they prepared the tabulation sheet on the basis of manipulated marks. During investigation, the IO seized some original as well as duplicate answer scripts, collected admitted handwritings of the arrested candidates, sent the seized answer scripts and duplicate answer scripts with admitted handwritings of the arrested candidates to the FSL, Forensic Lab, Lordship, and collected reports. The forensic officer gave report which establishes alleged manipulation. The investigating officer recorded the statements of a good number of witnesses under section 161 CRPC and under section 164 CRPC. 3 accused persons are made approver. On perusal of the oral testimonies of the witness recorded under section 161 and 164 and the statement of approvers, it appears that accused persons above mentioned prima facie committed offences which attracts various provisions of IPC and PC Act. During the course of hearing on charge, learned counsels appearing for the accused candidates have argued that the witnesses examined by the investigating officer do not implicate the accused candidates. The forensic reports are in favor of the accused persons. They are not the custodian of the answer scripts and they are not concerned what the officials of APSC did with the answer scripts. There is no evidence that the accused persons conspired with the officials of APSC or abetted them to do anything wrong. Their argument. It transpires that some of the answer scripts were recovered from the house and rented house of accused Rakesh Kumar Paul, and some of them were seized from the strong room of APSC. Some original answer scripts were not found. And then see what the court holds, Lordship. So a strong presumption goes against the arrested officials of the APSC that they destroyed those answer scripts without any authority. In some answer scripts, it appears that the marks had been increased. In some answer scripts, the signatures of the invigilator were found forged. Now the question arises, who were the beneficiaries of such manipulation of the answer scripts? Without any hesitation, it can be replied that the candidates whom the IO submitted charge sheet were the beneficiaries. If those manipulation would not have been done, definitely the net result of the examination conducted by APSC for CCE 2013 and CCE 2014 would have been different, and some genuine and brilliant candidates would have been selected. Now, Lordship, we can go to page 20, Lordship. Second paragraph from the top. As per prosecution, the APSC had to conduct the main examination for the year 2013 and 14 in the answer scripts printed at government press, but the recovered answer scripts were not printed at the government press, which is confirmed by the forensic expert. On behalf of the defense, it has been argued that in an RTI reply, the officer of the government press clarified that in the year 2013, no answer script was printed at the government press. This also argument, Lordship, has been reverberating here. It's been taken here. Whether the government press printed the answer scripts or not is a matter of trial. The officer who signed in the RTI has to clarify in the court that what information he has given was based on official record and true. Without examining the concerned officer at this stage, it is not safe to hold that the information given in RTI reply is correct. Then, Lordship, the next paragraph repeats the same thing about the answer scripts being found. Then, common submission of the defense is that the witnesses examined by the IO during the investigation do not implicate the accused persons, particularly the candidates. Mr. So-and-so, learned defense counsel, during the course of hearing submitted that the fate of the case is based on circumstantial evidence, and prosecution has to fill the chain of circumstances to come to the conclusion that the accused persons committed the offences as alleged. If that is so, without giving a chance to the prosecution to make the chain of circumstances and incidents to make the chain complete, it will prejudice the prosecution. Some witnesses have deposed that they saw the accused persons to meet accused Rakesh Kumar Paul at Satsang Bihar. Accused Rakesh Kumar Paul was chairman and candidates met him, talked to him before results, gives a strong suspicion. Now, Lordship, the argument that cognizance has been wrongly taken is dealt with in the next to next paragraph. It is a fact that the cognizance of offences is taken in absence of accused and on the basis of materials placed by IO. After taking cognizance, court processes were issued to the accused persons, and on the day of first appearance, the accused persons came to know under what sections cognizance of the offence was taken against them. If it was erroneous, please Lordship may mark, if it was erroneous, then it is the duty of the accused to challenge the order of cognizance before the Honorable High Court. As the accused persons have not challenged the order of taking cognizance, so they have accepted the same. So at the stage of charge hearing before the same court, such type of argument is not acceptable. Then,
25.
Lordship, page 25. Last, bottom of page 25, last para, Lordship. The accused persons mentioned above, during the above mentioned period, induced the informant candidates, guardians through a middleman, and that they would arrange job for them or for their wards, and compel the informant candidates, guardians to hand over huge amount of money through the middleman directly, and selected candidates who were not selected in the competitive examination and thereby the accused persons cheated the informant and genuine candidates, which is punishable under section 420. This is the charges are framed thereafter, Lordship, page 30. So, Lordship, all this is basically the charges, Lordship. So, Lordship may see from page 30 it starts, Lordship, all charges. And Lordship, we may come finally to page 33, which is the third para from the top, Lordship. In view of the above discussion and observation, the petitions filed by accused Basanta Kumar Dole, Nabakanta Patel, Mehboob Ali Chaudhary,
What was the page
Sayyid
number?
Mush.
What was the page number?
Lordship, this is page 33, third paragraph from the top. This is the last para I'm reading, Lordship. In view of the above discussion, Lordship. In view of the above discussion and observation, the petitions filed by Basanta Kumar Dole, Nabakanta Patel, Mehboob Ali Chaudhary, Sayyid Musharraf Hussain and Manas Pratim Holoi filed for discharging them are rejected. The Lordship, what are the undisputed facts? FIR is filed. Charge sheet against the appellants herein, Lordship, is there. Cognizance has duly been taken, Lordship. That cognizance order has attained finality, never challenged, Lordship. Charges have been framed, Lordship. And the discharge prayer by some of them, and particularly I come back to Manas Pratim Holoi, because that has been argued considerably at length here, has also been rejected. The same arguments that have been taken here, there are being taken here, Lordship. These are the undisputed facts. And that broadly covers the factual narration with regard to this case. I have, Lordship, taken the liberty of the order to quote that, read that order, because broadly it summarizes the entire facts that I would have otherwise argued. So, Lordship, in light of their discharge, what I could show, Lordship, for a minute is just if Lordship can now take the file of Kunal Das. And before I make my submissions, what were the submissions before the learned single judge, Lordship? I'm going to just show the relevant 3-4 annexures so Lordship can mark them for easy reference. We are taking the writ appeal?
Yes, writ appeal. This is the writ appeal.
128, Lordship. If Lordship, Ladyship has the writ appeal, Lordship may come to page 212 of the writ appeal. I'm just showing you the relevant annexures for Lordship to mark. Awesome. That will be chart 83. Lordship may just see, this is the, before the single judge, this was a chart or a table that we had prepared, Lordship, which broadly was the list of the petitions, Lordship. So we'll just note that for reference, it has 3 dates that are for each one of the appellants. It's their writ petition number that was before the single judge, Lordship. The name, Lordship may note the date of appointments are given, date of suspension, and date of discharge. So on this one, these 2-3 pages, Lordship, all the relevant dates with regard to their appointment, suspension, and discharge is available. Then, Lordship, I will take Lordship to the next annexures, the rules. That, Lordship, is at page 215. 215. I'm merely, Lordship, pointing out that all the relevant rules, Lordship, are available, and Lordship would see Assam Civil Service rules, police rules, taxation service, transport service, labor service, and discipline and appeal rules, Lordship. And if Lordship turns the pages, then those individual rules will follow, Lordship. Then Lordship may come to 365 are the appointment letters. Here, Lordship, I'll just show the 3-4 type of appointment letters. 365, Lordship. टेम्परेरी दिखा ना हाँ हाँ ठीक है चार्ज का ऑर्डर्स बता दो for record 318 what is it in the written appeal? Lordship may just mark at 365 onwards are all the appointment letters. I'm just showing the record, that's all. And Lordship at 447 are all the discharge orders. So every annexure, Lordship, has a summary table, and then Lordship, it has the date and the page number.
Board submission is taken to the, which was part of the submission of the state. Our board submission that we took before the bill. One of those was whatever course of repeat. Right.
I hope it's okay, Lordship. I've really compressed the facts because I think we don't need to go so much in detail. Now we are more in the law points, which is what I have to spend considerable time on. May I, Lordship? So, Lordship, Ladyship, what I'm now going to do is list out the core submissions one by one that we have taken. And obviously, these are our submissions before Lordship and Ladyship also. And I'm just giving the bullet points one by one, is that Lordship, our case is that none of these appellants deserved indulgence under the extraordinary jurisdiction or its power of Article 226. None of them deserve the indulgence under Article 226. Why? Because our case is, Lordship, that Article 226, 227, Lordship, is meant for equitable relief, particularly with regard to violation of a fundamental right under Part 3. With regard to the appellant's, Lordship, our case is quite contrary to any violation of a fundamental right. The detailed investigation, and it's detailed, Lordship, the detailed and thorough investigation by the police reveals the participation of these appellants to secure appointments in a fraudulent manner. And these appointments are to public offices. So therefore, their selection is fraudulent and they are the beneficiaries of a colossal fraud. In fact, I would use the word, they are the identified beneficiaries of this colossal fraud. Each one of the appellants, Lordship, as the investigation has revealed, participated and paid monies or illegal gratification to secure these appointments. So their entry into service is tainted. Next, Lordship, that is one leg. The second leg, Lordship, is that there is no alleged misconduct by them pertaining to official discharge of their duties. They cannot be equated with those who have got a bona fide entry into the service and have undertaken any misconduct while discharging their official duties. These are two separate classes. According to us, Lordship, and we will show the judgments to that effect, Lordship, the appointment itself is ex facie ab initio void. And it disentitles them, the manner of their entry, their tainted entry, disentitles them to continue in public office or to hold public office. Our cases, Lordship, under the law, settled law, we have followed the established law, settled law, in terms of identifying the beneficiaries, segregating the grain from the chaff. And therefore, what the state has done is, the action of the state is, in terms of discharging these identified beneficiaries of the colossal scam who have a tainted entry into the service, the action of the state, Lordship, is valid, legal, and in the larger public interest. Lordship, that's very important for us. And Lordship, I'm going to build on this, that the discharge is valid, legal, and in the larger public interest. Now, Lordship, while making each one of these arguments, Not once would we like to lose sight of the fact each one of them is a probationer. Each one, not one has a order of confirming them into service. So these are only probationers whose entry is tainted. Now, Lordship, we use the word that their continuation in office would be against public
No, but orders
interest.
of the governor was read. Orders passed by the governor was read to show that probation was confirmed.
I will satisfy Lordship. There is no confirmation, Lordship, may record it. All of them were probationers, and the law, Lordship, I'll take a moment only just to answer on the law. We'll be building on it because we have several judgments to that effect, Lordship. Essentially, Lordship, under the several judgments now, this question has come: when do you get a probationer becomes a confirmed employee? Now, Lordship, there are cases where the service rules mention a fixed period for probation. There are certain service rules where the probation period can be extended beyond the first initial period, 1 year, 2 year, whatever, can be extended for, say, another 2 years. There are certain service rules where the extension does not have an upper limit, and also there are some which have an upper limit. So the settled law, Lordship, is if there is no extended period of probation, then you would be deemed to be confirmed, provided there is nothing in the rule that says that a positive order of confirmation is required. The second leg is, Lordship, you will be deemed to be confirmed at the point of the maximum extended probation period. And Lordship, if there is a requirement of a positive confirmation of satisfaction of the governor, and if that is not there, then Lordship, that case also gets excluded. In this particular case, all the appellants, Lordship, all fall clearly within the probation period only. Not one has crossed the extended probation period. And that's why, Lordship, I'll be showing those rules on probation before I make the arguments. But essentially, Lordship, there is the period, initially 2 years, and then there is the extension. That's why I just requested Lordship to note those rules, but we'll be dealing with it in our compilation when I build my arguments on probation, Lordship. Now, Lordship, I said that their continuation in office is against public trust. I want to build this for a moment. Lordship, what are we talking about? We are talking basically of someone who is seeking to become, and the word used is a public servant. To occupy what? A public office. For what? To serve the public or in public interest. Now, Lordship, that is the primary focus of this entire employment. There is no personal interest that can govern this. And Lordship, what we have here is a tainted entry, identified people. So I ask myself, let us for a minute assume someone with such a grave allegation of having paid a certain sum of money to secure that appointment is sitting in the public office, in the police or the civil service or whatever. What is the confidence that this person will inspire when a member of the public comes to them seeking something to be done as part of discharge of their official duties? Can that office and its trust of the public in that office be exalted by the presence with someone who is so tainted? It can't be, Lordship. It just simply can't. As far as the state is there, we are obligated, and our ground is, we are obligated to act in a manner that keeps not just the efficiency and the credibility of the administrative service or the administrative setup, but does not diminish the public trust in the office itself. It's ungovernable otherwise. That's clearly, Lordship, why through the years, right from the last almost 20 years of judgments, Lordship, the Supreme Court has come down heavily whenever there has been an allegation of taint in securing orders, securing employment through a tainted mechanism. And Lordship, again, I'll come to those judgments, but just since I'm today on my preliminary arguments, there also, Lordship, the line of judgments on the examination system is clear. If it is not possible to identify the beneficiaries, or as the word used is segregate the grain from the chaff, if the fraud or manipulation of the system is so pervasive and widespread that it has contaminated the entire system, as we've seen, say, in mass cheating in examinations of schools and others, then the line of judgments is clear that you can scrap and you must scrap the entire examination process. Now, Lordship, within that, those who secured the employment through the examinations, some of them raised their arguments before the court and the Supreme Court that I am a bona fide entry. I worked hard, maybe sat for the exam 3 times, 4 times. It's not uncommon for many aspirants for multiple years to try before they make it into a service. Now, when I secure that entry through hard work, you are scrapping the examination. What happens to me? In that light, the Supreme Court has crafted it to say, if you can identify the beneficiaries, segregate the grain from the chaff, please don't cancel the entire examination. Now, in our particular case, Lordship, the numbers that I gave in the beginning, each one of these discharged persons, pursuant to the detailed investigation, pursuant to the forensic reports on the answer sheets, all of it, it was finally seen that there was a taint on them. They were all probationers or temporary employees. The government, therefore, took the decision to discharge them. I may also point out, Lordship, while we are today arguing it in 2025, the FIR was in 16. By 17 or so, Lordship, this was one of the most reported in the media. There was a PIL. There were demands, scrap the exam. There was in society, if I may use the word, great anger in terms of how the examinations were being conducted. And in light of that, the government also took a decision that it was important to preserve the sanctity of the civil service and administration and took the decision. Since I mentioned public trust, Lordship, I am only going to read out. We will later on, Lordship, it's part of our, in fact, Lordship can see the page also. It is part of our affidavit in opposition in writ appeal 75 of 20. It's already there before Lordship. My colleague has already given. If Lordship would be pleased to come to page 68, I'll be reading in that reply a passage from Tulsiram Patel, Lordship. No, Lordship, not yet on the compilation. I am going to the affidavit in opposition in Pallavi Sarma Chaudhary, which is writ appeal 75.
Readable 75. That's here. Readable 75. Readable 75 is item number.
Well, I'll just Lordship assess that.
Otherwise, my lord, Tulsiram Patel had handed over, my lord.
Okay.
1985 3 SCC 398.
Or if that judgment will also be ending, or Lordship can refer to it, I'm referring to para 44. 26 Lordship today. Item 26 today. Some judgment, Lordship, both sides are relying on, depending which paragraph. I am reading, Lordship, this passage, which is, after all, it's a constitution bench, Lordship, on public trust.
Page number?
68, Lordship. Para 8 quotes the relevant part of Tulsiram Patel.
68 is
written
of the
of our written submissions, Lordship, in the affidavit or in the Pallavi Sarma case. No, it's in the affidavit of opposition. Oh, written submission. Acha. Lordship, basically in the affidavit of opposition, we have placed at the end of it the written submissions of the state, which was before the learned single judge, and in running page it is 68. Otherwise, Lordship will refer to the judgment. I don't want to. Lordship is rising. Lordship has rate appeal as 75?
It will last for 68.
What's our item number, Bernard?
Yes.
Has Lordship got that? And Lordship 68, Lordship may see para 8?
Yes.
I'll just read that. It is most respectfully submitted that while dealing with a case where the selection process to public offices is tainted with fraud and illegality at the threshold itself, it becomes useful to refer to the following observations made by the Honorable Supreme Court in Union of India versus Tulsiram Patel, 1985, 3 SCC 398. Ministers frame policies and legislatures enact laws and lay down the mode in which such policies are to be carried out and the object of legislation achieved. In many cases, in a welfare state such as ours, such policies and statutes are intended to bring about socio-economic reforms and uplift of the poor and disadvantaged classes. From the nature of things, the task of efficiency and effectively implementing these policies and enactments, however, rests with the civil services. The public is therefore vitally interested in the efficiency and integrity of such services. Government servants are, after all, paid from the public exchequer, to which everyone contributes either by way of direct or indirect taxes. Those who are paid by the public and are charged with public administration for public good must therefore, in their turn, bring to the discharge of their duties a sense of responsibility. The efficiency of public administration does not depend only on the top echelons of these services. It depends on much upon all the other members of such services, even those in the most subordinate posts. For instance, railways do not run because the members of the railway board or the general managers of different railways or the heads of different departments of the railway administration. They run also because of engine drivers, firemen, signalmen, booking clerks, and those holding 100 other similar posts. Similarly, it is not the administrative heads who alone see to the proper functioning of the post and telegraph service. For a service to run efficiently, there must therefore be a collective sense of responsibility. But for a government servant to discharge his duties faithfully and conscientiously, he must have a feeling of security of tenure. Under our constitution, this is provided for by the acts and rules made under Article 309, as also by the safeguards in respect of the punishments of dismissal, removal, or reduction in rank provided in clauses 1 and 2 of Article 311. It is, however, as much in public interest and for public good that government servants who are inefficient, dishonest, or corrupt, or have become a security risk should not continue in service, and the protection afforded to them by the acts and rules made under Article 309 and by Article 311 be not abused by them to the detriment of public interest and public good. When a situation as envisaged in one of the three clauses of the second proviso to clause 2 of Article 311 arises, and the relevant clause is properly applied and the disciplinary inquiry dispensed with, the government servant cannot be heard to complain that he is deprived of his livelihood. The livelihood of an individual is a matter of great concern to him and his family, but his livelihood is a matter of his private interest. And where such livelihood is provided by the public exchequer and the taking away of such livelihood is in public interest and for public good, the former must yield to the latter. These consequences follow not because the pleasure doctrine is a special prerogative of the British Crown, which has been inherited by India and transposed into our constitution, adapted to suit the constitutional setup of our republic, but because public policy requires, public interest needs, and public good demands that there should be such a doctrine. Now, Lordship, while this was a case of Article 311, the Honorable Supreme Court in this landmark judgment has also laid down what are the expectations in terms of public interest, public good, and from those who man the public office in terms of the efficiency and about the confidence of the people in those offices.
We'll continue tomorrow.
I was about to ask Lordship before I continue.
record. Students of the appellants are present, including Mr. Anurag Chaudhary, Senior Counsel. The submissions of Mr. N. Kohli, Senior Counsel, assisted by so-and-so, remains inconclusive. List as a parted matter on 3/6/2025. Please get your names to the court master. We'll record it. We're going to fetch it now.
Lloyd. I better go.